3 awards, but they were all...
Just a few housekeeping issues. The proceedings are in English. Fortunately, we have a team of interpreters who will assist us so that every one of us understand what is going on. Secondly, the starting hours, it's still something that we're going to work on. It's 10 o'clock in the morning. It was supposed to have been 10 in the morning. Unfortunately, there were hiccups. That's why we're only starting now. But we shall sort this out during the course of the day, what hours we will be starting.
As a good business.
And the third thing, I'm sitting with assessors, and I would like to swear them in. Please stand up for the record. Please state your full names.
Janet Henson de Toy.
Do you have any objection against taking the oath?
No.
Do you swear that you will, on the evidence placed upon you, give a true verdict upon the issues to be tried? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. Please stand for the oath. State your full names for the record.
Temba Simon Mazibo.
Do you have any objection against taking the oath?
No.
Do you swear that you will, on the evidence placed before you, give a true verdict upon the issues to be tried? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You may be seated. Yes, Mr. Nell.
Please, the court, lady, would the court prefer that I read out the charges against the accused?
Yes, the accused is English speaking?
Indeed, my lady.
Yes, you may do so.
The first count against the accused, count 1, is one of murder, read with the provisions of section 51(1) of Act 105 of 1997. In that, upon or about 14 February 2013, and at or near 286 Bushvilla Street, Silverwoods Country Estate, Silver Lakes, in the district of Pretoria, the accused did unlawfully and intentionally kill a person, to wit, Reeva Steenkamp, a 29-year-old female.
Yes. That is count 1.
That's count 1.
Yes. Do you understand the charges, Mr. Pistorius?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
Please, the court and lady, count number 2, contravention of section 127 of the Firearms Control Act, Act number 60 of 2000. In that, the accused is guilty of the offence of contravention, of contravening the provisions of section 127, read with section 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, discharge of a firearm in a build-up area or any public place. My lady, I have to start the proceedings by asking that this charge be amended.
Yes.
There's a typing error.
Yes.
I'll read it. In that, honor upon 30 September 2012, my lady, the indictment reads 2010, and that's just a typing error, as can be seen from the alternative count. There's a reference to 2012.
Yes, so it should be amended to 2010.
30 September 2012, my lady.
12.
Yes, my lady.
That's the first. Oh, yes, I'm looking at the wrong one. That's count number 2.
Indeed, my lady.
Okay, it is amended.
I'll then read it again.
I should have asked if there are any objections.
There is no objection. Thank you, my lady.
Thank you very much.
I'll then read it again, my lady. In that, on or about 30 September 2012, and whilst driving in a vehicle with other passengers on a public road at or near Modderfontein in the district of Kempton Park, the accused did unlawfully discharge a firearm without good reason to do so by firing a shot with his own 9mm pistol through the open sunroof of the car they were travelling in.
How do you understand the charge?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
My lady, count 2 as an alternative, contravention of section 123B of the Firearms Control Act, number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 123B, read with sections 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, reckless endangerment. That reads, in that on or about 30 September 2012, and at or near Modderfontein in this district of Kempton Park, the accused in circumstances mentioned in count 2 above discharged a firearm with his 9mm pistol with reckless disregard for the other passengers in the car and or people in the vicinity.
Do you understand the charge that has been read out?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
This is a court, my lady, count 3. That's a contravention of section 127 of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 127, read with section 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, discharge of a firearm in a build-up area or any public place. The charge reads, my lady, in that during January 2013, and at Tasha's restaurant Melrose Arch in the district of Johannesburg, the accused unlawfully discharged a firearm to wit a Glock 27 pistol without any good reason to do so. Tasha's restaurant is a public place.
You've heard the charge that was just read out. Do you understand the charge?
I do, my lady.
How do you plead?
Not guilty, my lady.
Okay.
There's an alternative to count 3, a first alternative, my lady. Contravention of section 123A of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 123A, read with sections 1, 103, 121A, section 121, read with schedule 4, and section 151 of Firearms Control Act 60 of 2000, negligent damage to property. In that, on or about January 2013, and at or near Tasha's restaurant Melrose Arch in the district of Johannesburg, the accused negligently used a firearm to wit a Glock 27 pistol and caused damage to the floor of the restaurant.
Do you understand the alternative count?
I do, my lady.
How do you plead?
Not guilty, my lady.
Lady, there's a second alternative to count 3. Contravention of section 123B of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 123B, read with sections 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, reckless endangerment. In that, on or about January 2013, and at or near Tasha's restaurant Melrose Arch in the district of Johannesburg, the accused discharged a firearm to wit a Glock 27 pistol at the table in the restaurant amongst other patrons in a manner likely to endanger the safety of the people at his table and or other patrons and the property of the restaurant. The accused had, in discharging the firearm that was mentioned, shown a reckless disregard for the safety of the patrons or property of the restaurant.
Do you understand the count?
I do, my lady.
How do you plead?
Not guilty, my lady.
Thank you.
My lady, and then finally count 4. Contravention of section 90 of the Firearms Control Act number 60 of 2000. That the accused is guilty of the offence of contravening the provisions of section 90, read with section 1, 103, 117, 121A, section 121, read with the schedule 4 and section 151 of the Firearms Control Act 60 of 2000, and further read with section 250 of the Criminal Procedure Act 51 of 1977, possession of ammunition related. It reads, in that, on or about 16 February 2013, and at or near 286 Bushfellow Street, Silverwoods Country Estate, Silver Lakes, in the district of Pretoria, the accused did unlawfully have in his possession ammunition to wit 38.38 rounds without being the holder of a license in respect of the firearm capable of discharging the ammunition, a permit to possess ammunition, C, a dealer's license, manufacturer's license, gunsmith license, import, export, or in transit permit, or a transporter's permit issued in terms of the Act, or D, or is otherwise authorized to do so. Right, that's count 4, and that completes the indictment.
Yes. How do you understand count 4?
I do, my lady.
How do you plead?
Not guilty, my lady.
Not guilty. Mr. Roo? Is this in accordance with your instruction?
That is indeed so. Thank you, my lady.
Any explanation of
My
plea?
lady, Mr. Oldwaits will read the explanation into the record.
Thank you very much.
My lady, with the court's leave, I propose to hand up 3 original versions of the Section 115 plea explanation,
Yes.
which have been signed, as you will note, on the last page of the document by our client. I will also favour the State with a copy of this very same document.
Yes, please proceed. Yes, you may
With your
proceed.
ladyship's leave, might I then proceed to read it into the record?
Yes.
I'm indebted. In the High Court of South Africa, Gauteng Division, Pretoria, case number CC 113/13, in the matter between the State and Oscar Leonard Carl Pistorius, the accused, explanation of plea in terms of Section 115 of Act 51 of 1977, I, the undersigned Oscar Leonard Carl Pistorius, hereby furnish the following explanation of plea with reference to the charges to which I plead not guilty. At count 1, murder, read with the provisions of Section 51, subsection 1 of Act 105 of 1977. Paragraph 1. In its formulation of this count, the State has contended that I unlawfully and intentionally killed Reeva Steenkamp, hereinafter referred to as Reeva. Paragraph 2. This allegation is denied in the strongest terms. In fact, at the time of the tragic accident which led to Reeva's death, we were in a loving relationship. Paragraph 3. Whilst I admit that I inflicted the fatal gunshot wounds to Reeva, this occurrence was indeed an accident in that I had mistakenly believed that an intruder or intruders had entered my home and posed an imminent threat to Reeva and me. Paragraph 4. In my application for bail, I concisely dealt with the events of 14 February 2013. I am advised that I will have an opportunity to deal with a comprehension version of the events when I testify. For purposes of my plea explanation, I emphasize the following. Paragraph 4.1. During the early hours of the morning, I brought 2 fans in from the balcony. I had shortly before spoken to Reeva, who was in bed beside me. 4.2. Unbeknown to me, Reeva must have gone to the toilet and the bathroom at the time when I brought in the fans, closed the sliding doors, and drew the blinds and the curtains. 4.3. I heard the bathroom window sliding open. I believed that an intruder or intruders had entered the bathroom through the bathroom window, which was not fitted with burglar bars. 4.4. I approached the bathroom armed with my firearm so as to defend Reeva and I. At that time, I believed Reeva was still in the bed. 4.5. The discharging of my firearm was precipitated by a noise in the toilet, which I, in my fearful state, knowing that I was on my stumps, unable to run away or properly defend myself physically, believed to be the intruder or intruders coming out of the toilet to attack Reeva and me. Paragraph 5. I respectfully believe that the State has no basis whatsoever for alleging that I wanted to take Reeva's life. I will demonstrate hereunder that notwithstanding the fact that all the objective evidence will corroborate my version of the events, the State has embarked on a strategy to rely on unsubstantiated allegations in an endeavour to prove that I wanted to kill Reeva. Paragraph 6. The strategy was also employed at my bail application. I will hereunder concisely deal with some of the material aspects to support my contention herein. Paragraph 7. At my bail application, the State, inter alia, contended that I deliberately shot Reeva whilst I was positioned at a distance of about 1.5 meters from the toilet door, and whilst I was standing on my prosthesis. The allegation with reference to 1.5 meters and me wearing my prosthesis was clearly designed to suggest that I had pursued Reeva to the toilet and that I therefore knew that Reeva was in the toilet. Thus, that I did not entertain any fear at a time when it is alleged that I entered the bathroom. Paragraph 8. The state is also, by means of the evidence of the then investigating officer Hilton Botha, sought to rely on a statement by a witness who I am told is a certain Estelle van der Merwe, who claims to have heard what sounded like a woman's voice prior to the shooting, talking non-stop like fighting. The witness did not say that the alleged talking came from Reeva, nor that the sound so mentioned emanated from my house. Paragraph 9. The statement, it would appear, offered an opportunity for the state to contend at the bail hearing that there may, and this is a quote, my lady, there may have been an argument between the applicant and the deceased, and the evidence might point in that way, unquote. This witness has since deposed to a further statement, which materially contradicts her first statement. In the further and better particulars, the state disavows reliance on the first statement. The state has also conceded in the further and better particulars that they are not aware of any of the detail regarding, in brackets, the alleged argument, and that it may become clear during the trial. Paragraph 10. Van der Merwe's house is located approximately 105 meters from my bedroom, with my bedroom and bathroom windows facing in the opposite direction to Van der Merwe's house. It would not have been possible for Van der Merwe to have heard anyone talking from my bedroom in their bedroom. The state is furthermore in possession of statements by a number of witnesses, including witnesses resident in either the estate where I reside or in an adjacent estate. None of these witnesses claim to have heard any argument between Reeva and I, nor any woman's voice talking prior to the shooting, notwithstanding the fact that two of the witnesses, open brackets, who live in closer proximity to my house than Van der Merwe, close brackets, were awake at the time when Van der Merwe alleged that she had heard a woman's voice. Paragraph 11. I refer to the above as the state now alleges, and the further particulars provided, that there was, in fact, an argument between Reeva and I, and that I killed Reeva, in quotes, because of the argument, unquote. I am unable to comprehend on what basis the state, brackets at the bail application, close brackets, could only rely on a possibility of an argument between Reeva and I, and now, with even less available evidence, brackets, by disavowing Van der Merwe's first statement, close brackets, allege that there was in fact an argument, and that I shot Reeva, in quotes, because of the argument, unquote. Paragraph 12. I deny this allegation and reiterate that there is no justification, whether legally or factually, for this unfair and incorrect allegation to have been made. The aforesaid allegation is also not supported by any of the statements disclosed to me by the state. Paragraph 13. Furthermore, contrary to what was contended for by the state during the bail application, the state has now conceded that it cannot be contended as a fact that I was about 1.5 meters from the toilet door and that I had my prosthesis attached at the time when I discharged the firearm anymore. Paragraph 14. The unfair approach adopted by the state is further evident from the evidence given by Hilton Botha at the bail application, whose evidence will be demonstrated to have been false in material respects. More particularly, that it was designed to falsely incriminate me on an allegation of premeditated murder. It will also be demonstrated during this trial that whilst Botha was the investigating officer and tasked with preserving the scene, that the scene was contaminated, disturbed, and tampered with. This feature of the state's case will be dealt with when Botha, amongst others, gives evidence. Paragraph 15. I have been led to understand that it is unusual to challenge the state's case in my plea explanation to the extent that I do herein. However, I am left with no alternative but to explain my innocence with reference to the allegations levelled against me. The foregoing will be exposed by having regard to the state's intended approach in this trial. This approach is to not only seek to unfairly draw inferences from purported statements of fact, which are not supported by the objective facts, but also, by virtue of the statements disclosed to me by the state, to seek to introduce inadmissible character evidence under the guise that such inadmissible evidence would be admissible similar fact evidence, to demonstrate that there was an alleged nexus between the brackets, inadmissible, close brackets, character evidence and the brackets, non-existing, close brackets, argument, which allegedly led to me killing Reeva, paragraph 16. I'm furthermore advised that, as the state is aware of the fact that it has no evidence to prove an alleged argument, and in particular in view of the fact that the state has conceded that it does not know what the features or import of such alleged argument would have been, the only intended purpose of an attempt to introduce inadmissible character evidence would be to engineer and bring about an inadmissible attempted assassination of my character. I'm advised that during the conduct of the trial, my legal representatives will object to the introduction of such inadmissible character evidence on the basis as stated above. Paragraph 17. I respectfully state that no truthful evidence can ever be tendered that I fired the shots, and I quote, because of the argument, unquote. I deny this allegation in the strongest terms because there was no argument. Paragraph 18. The allegation that I wanted to shoot, in brackets, or kill, close brackets, Reeva, cannot be further from the truth. Add count 2. Contraventions of section 120, subsection 7 of the Firearms Control Act number 60 of 2000. Alternatively, to count 2, a contravention of section 120, subsection 3, subparagraph B of the Firearms Control Act number 60 of 2000, and paragraph 19. The allegations is formulated in the indictment with reference to this count, and the alternative count thereto are denied. Add count 3. Contravention of section 120, subsection 7 of the Firearms Control Act number 60 of 2000. The first alternative to count 3, contravention of section 120, subsection 3, subparagraph A of the Firearms Control Act number 60 of 2000, as well as the second alternative to count 3, contravention of section 120, subsection 4, subparagraph A of the Firearms Control Act number 60 of 2000, as per paragraph 20. I admit that whilst I was in possession of the firearm as alleged, a shot went off. Save as aforesaid, the remaining allegations as contained in this count are denied. Add count 4. Contravention of section 90 of the Firearms Control Act number 60 of 2000, as contained in paragraph 21. I admit that at all times relevant to this count, I had not been issued with a license to possess .38 caliber rounds of ammunition. Save as aforesaid, the remaining allegations as contained in this count are denied. My lady and learned assessors, that then the plea explanation as envisaged in terms of section 115 of the Criminal Procedure Act, the statement before you with respect has been signed by my client. He will no doubt confirm that in due course on this very day, the 3rd of March 2014. As your ladyship, please.
Thank you very much. Mr. Pistorius, do you confirm the explanation as read out?
I confirm, my lady.
Thank you very much.
My lady, might I then respectfully request that an exhibit number be allocated to the plea explanation?
Yes, what do you suggest we give it?
Maybe AA, my lady. I suggest AA.
Yes, this is exhibit AA. Yes, Mr. Nair.
Lady, as is accustomed in matters, there are certain admissions in terms of section 220 of the Criminal Procedure Act.
Yes.
My lady, we've prepared files. I beg leave to hand them in, and then I'll read the admissions into the record. My lady, it comprises 2 sets of files.
My lady, I'm so sorry. May the accused be seated?
Yes,
in
yes,
the
please. You
Thank
may
you,
be
ma'am.
seated. Is it 2 files?
It's 2 files for each,
For each.
member of the bench.
Thank you.
Lady, I'll take the court through the admissions.
Yes.
The admissions is drafted on a document, and we beg leave to hand that up as Exhibit A. The document containing the admissions would then be marked as Exhibit A, my lady.
Yes, this is Exhibit A.
And it reads, admissions under Section 220 of the Criminal Procedure Act, 51 of 77. The accused makes the following admissions as far as count 1 is concerned. The deceased in the matter is Reeva Steenkamp, in a lifetime an adult female. The deceased died on the 14th of February 2013 as a result of multiple gunshot wounds sustained on the same day and at the location described as 286 Bushwillow Street, Silverwoods Country Estate, Silver Lakes, Pretoria. Number 3, my lady, the gunshot wounds sustained by the deceased were inflicted by the accused. Number 4, the body of the deceased sustained no further injuries from the time of her death until the post-mortem examination was conducted on her body. Number 5, on 14 February 2013, the accused was resident at 286 Bushwillow Street, Silverwoods Country Estate, Silver Lakes in Pretoria. Number 6, Melanie. On 15 February 2013, Dr. Gert Simon conducted a post-mortem examination on the body of the deceased and correctly recorded his findings on Form GW7-15 with reference to the death register number 0188 of 13, a copy which is annexed here to marked Exhibit B. Lady, in the one file under Exhibit B would then be the post-mortem report.
Yes.
I beg leave that that then be marked as Exhibit B. Ma'am.
This is Exhibit B.
As God pleases. 7, the photo album, album 13, images 1103 to 1130, compiled by Warrant Officer van Staden, depicts images of photographs taken during the post-mortem examination, annexed here to as Exhibit C. Lady, in the file it's marked C. I beg leave that it be marked C as Exhibit C.
That's the photo album 13.
That's a photo album of the post-mortem examination,
Yes.
my lady.
This is Exhibit C.
As the court pleases. Number 8, the accused formally applied for bail in Pretoria Magistrates Court. A copy of the transcript of the bail proceedings is annexed here to as Exhibit D and is a true reflection of the proceedings and the evidence led. My lady, the second file is the bail application, and that should be marked with this. I respectfully request as Exhibit D.
This is marked Exhibit D.
As the court pleases. Number 9. The accused was legally represented throughout his bail application by Advocate Drew Essie and Advocate Aldrich on the instruction of Ramsey Webber attorneys, and all the accused's rights and consequences of his actions in relation to the bail application as provided for in terms of Section 60 of the Criminal Procedure Act, number 51 of 77, were explained to him. He understood same. The record is accepted as being admissible as evidence. Number 10. The photo album, album 1, attached here to is E. Lady, it's in the file under E. I beg leave that that then be marked, my lady, as Exhibit E.
This is Exhibit E.
The admission reads further. Photo album 1 attached here to is Exhibit E, images 1 to 171, compiled by Warrant Officer van Staden, is comprised of photographs taken at 286 Bushwillow Street, Silverwoods Country Estate, Silver Lakes, Pretoria, provided that it's not admitted that all the photographs in the series depict the scene as it appeared immediately after the shooting incident, as the scene was contaminated and or disturbed and or tampered with. Contamination and or disturbance and or tampering with the scene will be dealt with on behalf of the accused during the cross-examination of Hilton Botha, who was the investigating officer and the person who took charge of the scene. Such contamination and or disturbance and or tampering with the scene will also be demonstrated by having regard to other photographs, including certain photographs in the series number 172 to 914. My lady, in terms of the admission, the photographs are admitted, but not as a true reflection without being tampered with, and that is how it's understood by the state, that it's admitted with that proviso. 11. The photo album 11, attached here to as Annexure F, my lady, if I refer to the file again, under the red F, that photo album, it's indicated photo album 11, if that could be marked as Exhibit F, my lady.
This is Exhibit F.
School, please. Photo album 11, attached here to Exhibit F, images 915 to 951, compiled by Warrant Officer van Staden, depicts aerial photographs of the accused residential estate, as well as certain distances recorded thereon, between the accused's house and the houses of certain witnesses. It will be, lady, again a typing error, it should read, it will be alleged by the accused that such distances were not measured to the balcony door of the main bedroom of the accused residence. May I respectfully request that the word alleged be entered.
Inserted. Yes. Please proceed.
Please, number 12. Photo album 14, attached here to as Exhibit G, images 1131 to 1141, compiled by Warrant Officer van Staden, depicts photographs taken at Tasha's restaurant in Melrose Arch. My lady, it's filed under G. I respectfully request that it be marked as Exhibit G, my lady.
Yes, this is Exhibit G.
The photo album 15, attached here to as Exhibit H, images 1142 to 1147, compiled by Warrant Officer van Staden, depicts photographs taken at the R25 and M78 roads, Laurie Road, Modderfontein. Lady, it's filed in the file as Exhibit H. I respectfully request that it be marked as Exhibit H.
I see H1.
My lady, that's how they did it. It's H and I. I'm not using I.
Oh, I see.
So, my lady, I respectfully request that it be marked as.
Yes, this is marked Exhibit H.
We will not use I, my lady.
Thank you.
14. The affidavit in terms of Section 2123 of Act 51 of 1977 of Elizabeth Johanna de Jager correctly refers to the records of the weather conditions that prevailed for the Pretoria East area on 14 February 2013 during the hours of 3 and 4. A copy thereof is annexed here to marked Exhibit J. Likewise, it's JK. I've filed J and K there. May I respectfully request that the affidavit of Elizabeth Johanna de Jager, that be marked, my lady, as J.
This is Exhibit J.
Then further, my lady, the findings of Lieutenant Colonel Ian Glenn van der Nest with reference to the investigation of the crime correctly record as follows: that no injuries consistent with blunt force trauma were noted at the post-mortem examination, which would have resulted in external blood loss. Lady, there was another paragraph that was deleted, so may I respectfully ask that the word "and" just be deleted.
Yes, what paragraph is this again? 15.
15.1, my lady, ends with the word "and." May I respectfully request that the "and" just be deleted.
Thank you. I've done that.
This is 16.
Yes.
The certificate in terms of Section 2124A and 2128A of the Criminal Procedure Act 51 of 77, as certified by Estelle Mariana Deisel, correctly records a concentration of alcohol in a specimen of blood that was taken from the accused on 14 February to be 0 grams per 100 milliliter. A copy of this certificate is annexed here to mark K. My lady, it's under what we mark J and K. May I respectfully ask that the affidavit of Estelle Mariana Deisel be marked as K. It's the last statement under J and K, my lady.
Yes, I found it. This is Exhibit K.
As a court pleases. The analytical report compiled by Dr. P.J. van der Merwe with reference to the result of 2 urine samples obtained from the accused on 14 February 2013 correctly reports that no substances comprised of anabolic steroids, stimulants, narcotics, or diuretics could be detected in the sample so analyzed. A copy of this analytical report is annexed here to marked Exhibit L. Lady, we filed it under L. May I request that it be marked L?
Yes, that's Peter van der Merwe. Is that the one?
Indeed, van der Merwe.
Yes. This is Exhibit L.
So, court pleases, as far as count 3 is concerned, it's an admission. A shot went off whilst the firearm was in the possession of the accused. As far as count 4 is concerned, the accused at all times relevant to count 4 had not been issued with a license to possess .38 caliber rounds of ammunition. As the court pleases, that then the admissions in terms of section 2.2.
Thank you very much. Mr. Roux, do you confirm the admissions?
It is indeed confirmed. Thank you, my
Yes.
lady.
Thank you very much. Thank you.
The state then ready to call its first witness, my lady. I call Michelle Berger, number 80 on the list of witnesses.
Yes. Before you do that, there's no opening address.
I will do so, my lady. If the court would require me to do that, I will indeed do so. Lady and learned assessors, this matter deals with an incident that took place in the early hours of 14 February. The accused, the state's version, shot and killed the deceased as indicated in 286 Bushville country, in the country estates as indicated. They were the only 2 people in the house, my lady. There were no eyewitnesses. The state's case is based on circumstantial evidence that includes evidence of what the neighbours in the accused estate as well as neighbouring estates heard. We will lead ballistic and forensic evidence. We will also argue that there's certain inference to be drawn from the scene. Lady, we argue that the accused version during the bail application and today cannot be reasonably possibly true, should be rejected, and as the only inference from the circumstantial evidence would be that the accused shot and killed the deceased with direct intent to kill. There's no eyewitnesses, my lady, based on circumstantial evidence.
Thank you. Thank you very much.
As the court pleases, I then call Michelle Berger. My lady, may I? There was a judgment indicating that all witnesses that gave evidence could be recorded and shown, audiovisual recordings. My lady, we've objected on behalf of this witness,
Yes.
and the ruling was that this particular witness and the ones that would follow, that I would include the court, that would inform the court about, evidence should not be recorded and shown, either on a video recording or still photos. My lady, there's then a second issue. We not only have this court, we also have an overflow court. So I beg the court's finding that the court would order that also in the overflow court, the witness's face is not shown.
Okay. The overflow, they're hearing us, aren't they?
The overflow court can hear us, my lady, yes.
The part of these proceedings.
Indeed, my lady.
Yes. So it does apply. I do order that the face of this witness should not be shown.
As a good bit.
Yes. Is there anything else?
That's it.
No, that's it. Thank you.
She testifies in Afrikaans, Your Ladyship. Volle naam en voor.
Michelle Burger?
Enige besort in die aflê van die voorgeskrewe eed?
Nee.
Besko u dit bindend op u gewete?
Dis reg.
Zweer u dat die getuienis wat u gaan aflê die waarheid, die volle waarheid en niks anders as die waarheid sal wees nie? Steek op u regterhand en sê so help my God.
So help my God.
My lady,
You may be seated if you so wish.
we will lead the witness in English. The witness would respond in Afrikaans. That. Are you comfortable? Madam, what business are you in?
Ek's 'n dosent by die Universiteit van Pretoria.
I'm a lecturer at the University of Pretoria.
In which department, madam?
Edele, ek is by die departement konstruksie-ekonomie,
I'm at the Department Construction
economics.
Madam, the accused before court is Mr. Oscar Pistorius. Do you know him?
Edele, ek het hom nog nooit ontmoet nie, ek ken hom nie.
My lady, I've never met him before.
Before this incident, madam, did you know where he stayed?
Edele, ek het geweet hy woon in die Silverwoods estate, maar ek het nie geweet waar nie.
I did know that he was staying in the Silverwoods estate, but I did not know where.
Madam, on the 14th of February 2013, where did you stay?
Edele, ek woon in Silverstream landgoed in Pretoria. Ek het daar gewoon op daardie datum en ek woon steeds daar.
My lady, I stayed in the Silverstream estate on that date, and I am still staying there.
And who shares the house with you, madam?
Edele, my man, Charles Peter Johnson, woon saam met my.
It's my husband, Charles Peter Johnson. He stays with me.
How long have you been staying there, madam?
Edele, ons het in 2011 ingetrek.
We moved in 2011, my lady.
Now, your estate and the Silverwoods estate, are they next to each other?
Ja, dis aangrensend tot mekaar. My huis is teen die grens van die Silverwoods landgoed in Silverstream estate.
Yes, they are next to each other. Huis grens van dit.
Ja.
My house is next to the border of the Silverstream and the Silverwoods estate.
Now, madam, this matter deals with an incident that happened on the 14th of February 2013, early morning hours. You know that?
Yes, I do.
Now, on the evening of 13 February 2013, was anything special at your house, madam?
Edele, dit was 'n aand soos enige ander aand gewees. Ek en my man was by die huis gewees. Ons het aandete geëet, ek het kos voorberei en ons het gewone tyd gaan slaap wat gewoonlik tussen 9:00 en 10:00 is.
Just 1 minute. Give Ms. Boshan time to interpret. Yes.
My lady, it was an evening like any other evening. We were at home, we ate dinner, I prepared food, and we went to bed at our normal hours, which is between 9 and 10.
Then, madam, what happened?
Edele, net na 3 die oggend het ek wakker geword van 'n vrou se verskriklike gille.
My lady, just after 3, I woke up from a woman's terrible screams.
Ek het regop gesit in die bed en my man het ook wakker geword van die gille.
I sat upright in bed, and my husband also woke up from the screams.
My man het opgespring en balkon toe gehardloop.
My husband jumped up and went to the balcony.
Ek het nog in die bed bly sit. Ek het al gille gehoor.
I was still sitting in the bed and I heard her screams.
En sy het hom hulp geroep en toe na dit
You'd have to slow down a little bit.
Okay.
You're still sitting on the bed, yes?
You were saying?
U edele sy het verskriklik gegil en toe het sy hom hulp geroep.
She screamed terribly and she yelled for help.
U edele en toe hoor ek 'n man ook om hulp roep. Hy het 3 keer help geskree.
Then I also heard a man screaming for help and
Hy keer 3 times.
3 times he yelled for help.
Yes, and then?
U edele, ek sê toe vir my man, ek skree vir hom om te help nie, hy staan op die balkon nie. Hy moet terugkom na die kamer toe, dat ons sekuriteit kan ontbied.
I then told my husband that it doesn't help him standing on the balcony. He must come back into the room and that we should call the security.
Yes.
U edele, my man het toe teruggekom en ek het my selfoon is langs die bed. Ek het toe my selfoon gevat en ek het security op die foon gedruk.
My husband came back into the room. My cell phone was next to my bed. I took my cell phone and then I dialed for security.
And you dialed security. What did you do with your phone?
U edele, ek het dit toe vir my man gegee dat hy kan praat met die sekuriteit want ons is in Silverstream estate en ek het gedink ek moet Silverstream sekuriteit bel sodat hulle Silverwoods kan ontbied en sê daar's 'n huisaanval, mense word aangeval in hulle huis want dis wat ons gedink het as gevolg van die gille.
Okay, let's get that.
I gave my phone to my husband so that he can speak to them because we stay in Silverstream estate and I thought that our security should call Silverwoods estate to tell them that there was an attack in a house there.
Yes.
Die edele, my man het toe op die foon gepraat en vir die sekuriteitpersoon wat aan die ander kant was verduidelik, mense word langsaan aangeval, hulle moet asseblief gaan kyk.
My lady, my husband talked on the phone and explained to the security that there are people next door being attacked and that they should go there.
Yes.
Die edele, my man het toe die storie herhaal want die sekuriteit op die foon het toe die foon vir iemand anders te gegee en my man het die hele storie toe herhaal en gesê van die aanval in die huis.
My lady, my husband repeated the story because the phone was given to another person, so my husband repeated the story and explained that someone is being attacked in a house.
Yes. Your husband repeated the story and what happened then?
Die edele, hy het toe vir my gesê, dis Troebenkop sekuriteit. Dis die verkeerde sekuriteitsnommer wat ons gebel het. Dis 'n plek waar ons voorheen gewoon het. En hy het die foon neergegooi.
He then told me that it's Troebenkop security. It's the security of a place where we lived previously. He said it's the wrong security and he dropped the phone.
Yes.
Die edele, my man het toe teruggehardloop na die balkon toe. Ek sit nog steeds in die bed. En toe hoor ek weer haar gille. En dit was erger as voorheen. Dit was meer intens.
Okay.
My husband then ran back to the balcony. I was still sitting in bed. I heard her screams again. It was worse. It was more intense.
Yes.
Die edele, sy was vreesbevange geweest. Dit is die ergste. Dit was soos 'n klimaks. Ek het haar angs gehoor en ek het geweet iets gaan kom. Iets verskrikliks gebeur in daardie huis.
Apologies, my lady. May I ask her to just repeat what you said?
Please repeat.
Kan jy net vir my herhaal?
You were saying the screams were more intense, and then
it was a climax. She was very scared. It was screams that was a climax.
Okay. And what happened then?
Edele, na haar gille, enkele oomblikke na dit het die skote geklap. Daar was 4 skote gewees. Die tyd tussen die eerste en die tweede skoot was 'n bietjie langer as tussen die tweede en die derde en die derde en die vierde skoot.
Just after her scream, my lady, I heard 4 shots. It was 4 gunshots that I heard. The time between the first and the 4th shot was much longer than between the second and the third one.
There were 4 shots. You said the first. Could you perhaps give us a demonstration by using bum?
Dit was edele byvoorbeeld gewees bang. Bang, bang, bang. Daar was 'n groter pose tussen 1 en 2 as tussen 2 en 3 en 3 en 4.
There was a longer pause between number 1 and 2 than between number 2 and 3 and 3 and 4.
Edele, ek wil ook vir die hof net sê, ek was nie met 'n stopperlosie daar nie, maar ek kan sê die tyd tussen nommer 1 en 2 was langer as tussen 2 en 3 en 3 en 4.
My lady, I was not there with a stopwatch, but I can tell the court that the pause between 1 and 2 was much longer than number 2 and between number 2 and 3 and 3 and 4.
And what happened then after the shots, madam?
Edele, my man het toe teruggekom na die kamer toe. Ek was nog steeds in die bed waar ek gesit het.
My lady, my husband returned then from the balcony and I was still sitting in bed.
Edele, ek sê toe vir my man, ek hoop nie daai vrou het nou net gesien hoe haar man voor haar doodgeskiet is nie. Want ons het hom nie weer gehoor na hy help geskree het nie, so ek het gedink hy's dalk geskiet.
Then I told my husband that I do not hope that that woman saw her husband being shot in front of her, because after he screamed for help, we did not hear him again.
What happened after that, madam?
Edele, ek was maar dit in mekaar aand, ek het gelê, ek was wakker en ek het geslaap. Ek het opgestaan die volgende oggend soos gewoonlik.
My lady, it was a confusing evening because I was sleeping and then I was awake and then I sleeping again, and then the next morning I woke up again, or I got up again. My normal time, I woke up.
Edele, ek het toe klaar gemaak om werk toe te gaan. My man was besig om opmetings te doen. Hy het gedink hy moet ons sekuriteit opskerp weens die huisaanval.
I was preparing for work and my husband was upstairs doing measurements because he thought that he should have to increase our security because of the attack in the house.
Edele, ek wil net duidelik maak, my man was nie bo besig om opmetings te doen nie. Hy was op, maar besig om opmetings te doen in die huis.
My apologies, my lady. My husband was not upstairs. He was up and was busy doing measurements in the house.
Madam, before we continue, can you just have a look at this file? And if you have a file with you, you can open at F.
How do you refer to this file?
Indeed, my
How
lady.
do you identify it?
It's Exhibit F, my lady. Its photographs are a further witness to that.
Just give us 1 minute. Yes, we've got
That's good. Please, ma'am, please page to 921. Slide 921. There. Well, ladies, simultaneous with reference to the exhibit, it will be screened on all the different screens in court as well.
Thank you.
Madam, having regard to that aerial photograph 921, can you confirm where your house is?
Eerlik ek kan.
Lady, I'll just put on record. The witness is pointing towards a roof just above 46A Trevor Crescent. The roof she's referring to is just above the T of Trevor Crescent.
Yes.
Is that correct?
Eerlik, dis korrek.
That is correct.
And if looking at the photograph and just look at the numbers, the 191 and 193 would be in what estate would they be? The estate next door.
Eerlik, dit sal in Silver Woods wees want ons is teen die grens van Silver Steen.
It would be in Silver Woods because we are just next to the border of Silver Woods.
Let us then go to photograph 930, 930. Are you there, madam?
Eerlik is daar.
Does it look
Yes.
familiar?
Ja, dit is my balkon daai.
Yes, it's my balcony.
Yeah. If we just explain to the court, you in your evidence said your husband went to the balcony. Which balcony did you refer to?
Eerlik is hierdie balkon op hierdie foto.
I'm referring to this balcony on this photo.
Yeah. The house you're staying in, is it a 1 or 2 story house?
Eerlik is 'n dubbelverdieping huis.
It's a 2-story house.
And this balcony is on which floor?
Eerlik is op die boonste verdieping.
It's on the top level.
There is a little red arrow. Does that look familiar to you?
Ja, eerlik, dit is wat ek verstaan meneer Oscar Pistorius se huis is, die badkamer van sy huis.
Yes, from what I understand, that is where Mr. Oscar Pistorius' house is. His
Bathroom.
bathroom.
Let's just turn the page to 931. Does it look familiar to you?
Ja, eerlik, dit is ook van my balkon afgeneem.
Yes, that was also taken from my balcony, my lady.
And you confirm the red arrow again.
Eerlik, dit is meneer Oscar Pistorius se huis.
My lady, that is Mr. Oscar Pistorius' house.
And number 932, madam.
Eerlik, ek verstaan dit is die badkamer venster van meneer Pistorius se huis.
If you're on the balcony, could you see that specific house?
Ja, eerlik.
Yes.
Good. Madam, now your bedroom, on which floor of the house is that?
Eerlik, my slaapkamer is op die boonste verdieping en die vensters kyk uit na die Silver Woods landgoed toe.
My bedroom is on the second level, and the windows
Face out. Face towards.
face towards the Silver Woods estate.
Now, do you have windows in your room?
Edele, ek het slaapkamervensters wat waarwyd oop was, want ons het nie 'n ligreëling of 'n dakwaaier nie.
My lady, I had bedroom windows which was wide open because we do not have air conditioning in the bedroom.
Or 'n fan.
Or a fan.
What happened the next day? I just want to go back to the screams you've heard. Did that have any effect on you?
Edele, dit was verskriklik traumaties geweest, die angs. Dit was bloedstollende gille geweest. Dis die tipe ding wat jou koud laat. Jy kan dit nie mooi oordra aan iemand nie. Dit was verskriklik, die stem.
It was very traumatic for me. You could hear that it was blood-curdling screams, and
You can't translate it in words.
It leaves you cold. You can't translate it in words. The anxiousness in her voice,
Fear.
And fear.
Next day, what do you think happened?
Ek het nie geweet, ek het gedink is 'n huisbraak. Ek was oortuig ek en my man, mense is aangeval in hulle huis in Silverwoods. Dis wat ons gedink het.
I was not aware. I thought it was a housebreaking. My husband and I thought that someone was attacked in the house in the Silverwoods estate.
And what did you do, madam?
Ek het maar werk toe gegaan soos enige ander dag. Ek het toe ook 'n vriendin gebel op pad werk toe.
I went to work like with any other day, and I also called a friend on my way to work.
Yes.
My vriendin se kind is in die Silverwoods kleuterskool, so ek het haar gebel om haar te vra, kan sy asseblief uitvind wat het gebeur, en ek het haar die storie vertel.
My friend's child is in the Silverwoods nursery school, and I asked her if it's possible, if she could find out what happened.
And you also said you told her the story.
Is reg, U Edele, ek het vir haar die storie vertel.
That is correct. I told her the story.
What story did you tell her? Don't repeat the story, but what story did you tell her?
U Edele, ek het haar vertel van die vrou se verskriklike gille en die skote.
My lady, I told her about the woman's terrible screams and the gunshots that I heard.
U Edele, ek het vir haar gevra, ek wil hoor of iemand dood is en wat het gebeur.
I asked her, I want to find out if someone died.
By die ek het gesien.
Boshoff.
Edele, ek het toe, ons het maar gesels soos elke oggend. Hy het gevra hoe gaan dit en ek het hom vertel van my slegte nag.
We talked like every morning, and I told him about the bad morning I had. Bad night. Apologies. Also another colleague, Vita Wilkins, and we talked, and I told her of the house breaking I thought took place the previous night.
Yes.
Edele, en ek het toe begin werk en later het my man my
I started working, and then later on my husband called me.
Yes.
Edele het vir my gevra of ek kan onthou wat die vorige aand gebeur het en ek het gesê natuurlik.
He asked me if I could remember what happened the previous night, And I said yes.
U edel, en ek het hom toe vertel, soos wat ek het gehad het, soos wat ek aan die hof verduidelik het.
I then told him as I just explained to the court.
U edel, hy het vir my gesê, hy het nou net by die kantoor gehoor, en hy het nou net agtergekom, meneer Oscar Pistorius is op die nuus, en hulle sê, hy het gedink daar's 'n inbreker, en toe het hy sy meisie doodgeskiet.
He then told me that at the office he just heard that Mr. Oscar Pistorius is on the news and he thought that there was an intruder and then he shot his girlfriend.
Just 1 minute.
Yes.
Is this just hold on?
Sorry?
This is not hearsay evidence.
A husband will be a witness.
Will
my
be.
lady. Yeah.
Oh, thank you. Thank you.
U edel, dit was toe op die nuus gewees, my man het toe eers die nuus agtergekom.
It was on the news and then my husband only then realized.
And when you heard that, what did you think?
U edel, ek het vir my man gesê, dit kan nie wees nie, want dit rym nie met wat ons gehoor het nie.
I told my husband that it cannot be because it's not
That's not wrong
it
with
was
what we heard.
it's not what we heard.
Madam, how did it come about that you made a statement to the police?
U edel, ek het eers later 'n verklaring afgelê, want ek woon nie in Silverwoods nie.
I only made a statement later on because I do not live in Silverwoods.
En ons was oortuig gewees daar sou mense in Silverwoods wees wat sou gehoor het, want dit was baie duidelik vir ons wat gebeur het.
And we thought that there would be people in Silverwoods that estate that heard
That would testify.
that would testify
Because we're not in that estate.
because we are not in that estate.
Yes.
U edel, ek en my man het toe weggegaan tydens die voorverhoor en ons het die voorverhoor op die radio gehoor.
We went away during
Pre-trial
we went away during the pre-trial, and
on the radio.
we heard of the pre-trial on the radio.
You referred to something as a pre-trial, but you heard a judgment on the radio.
Dis korrek, u edel.
That is correct.
Mm-hmm. And what
En
then?
u edel, op die radio het ons gehoor, daar word gepraat van 'n getuie wat 600 meter weg is. Ons het toe intussen agtergekom, ons woon nie te ver van meneer Pistorius nie, want daar was 'n ligfoto op die TV gewees van ons huis.
We heard on the radio of a witness that stays 600 meters far, and we then realized that we do not stay that far from Mr. Pistorius because we saw an aerial photo on the television of our house.
Yes.
U edele, verder by ons werke het almal toe nou besef hoe belangrik ons getuie is, want ons kollegas het gehoor van wat ons gedink het die huisbraak is, voor baie van ons geweet het, dit is meneer Pistorius.
At our workplaces, we then realized how important our testimony is because our colleagues heard of the housebreaking before we knew
Dat het Mr. Pistorius.
before we knew that it was Mr. Pistorius.
And then what did you do?
Edele, ons het toe probeer uitvind wat ons moet doen. Ons is nie eintlik media mense nie. Dit is vir ons erg om hier te wees. Ons is private mense.
We then tried to find out what we should do. We are not really media people. It's difficult for us to be here.
Edele, ek het toe 'n prokureur gebel en ook 'n advokaat, Nikki Marits wat ek ken.
I then contacted an attorney as well as an advocate that I knew, Nikki Marits.
Edele, om advies te kry oor 'n verklaring. Hoe moet ons maak om 'n verklaring af te lê?
To get advice regarding the statement, how we should go about to give a statement.
Edele, want ons het gehoor as ons na die polisiestasie toe gaan, dan die media op daardie stadium was baie erg. Ons wou dit privaat gehou het.
We heard that when we go to the police station, the media at that stage, it was very intense, and we wanted to do it privately.
Die edele advokaat Marit het toe gesê ons moet ons verklaring so lank neerskryf en dan kan ons by mekaar kom. Maar voor dit gebeur het die polisie aan ons deur geklop een aand.
Advocate Marit told us that we should write down our statement and then thereafter we could get together. But before that, the police knocked on our door one evening.
And you made a statement with the police when they came back.
Die edele polisie was toe daar, hulle het met ons gepraat en hulle het gesê kaptein Mike van Aert sal 'n draai by ons maak om die verklaring af te neem.
The police was there and they talked to us, and then they informed us that Captain Mike van Aert will come to get the statement from us.
And did that happen?
Die edele, dit was so, kaptein van Aert het gekom en ek het eers het hy geconsulteer met my man apart. Hy het sy verklaring afgelê en toe later met my.
That is correct. Captain van Aert was there. He firstly consulted with my husband separately and took the statement and then consulted with me.
Madam, there will be other witnesses in this matter. The Stip family. Did you know them before this incident?
Die edele, ek het hulle glad nie geken nie. Ek het hulle 'n week of 2 terug vir die eerste keer ontmoet.
I did not know them at all. I first met them about a week or 2 ago.
Die edele, net toe ek die hof besoek het om te sien hoe lyk die hof.
It was when I visited the court just to see how the court looks.
There also be the witnesses van der Merwes. Did you know them?
Die edele, ek het hulle nog nooit ontmoet nie. Ek het hulle vanoggend vir die eerste keer gesien.
I have never met them. I saw them the first time this morning.
Milady, it's 10 to 1. May I inconvenience the court and ask that we take an early lunch?
Yes.
Be back at 10 to 2. And I just want to go through the notes. I'm sure I'm done. I just want to go through the notes and then we can proceed from there, Milady.
Yes, thank you very much. There's no objection to this request?
I don't think it will help me, my lady, but no, thank you.
Very wise. Court will adjourn.